I have several things that I would like for you to answer for me. The first one is, can you tell me how long you've been in practice?
I've been in practice about 20 years, a little over actually. I think it's now 22. Time keeps flying.
And how many years have you been involved in defending the constitutionality of sign ordinances for local governments?
Virtually that entire time. I have done more First Amendment work than most attorneys, and I've worked in both the adult entertainment on behalf of local governments and sign litigation on behalf of local governments. I also currently do sign ordinance reviews for the Georgia Municipal Association, where different cities can send in their ordinances, and I will analyze them and provide them with some guidance on what needs to be fixed.
Is it correct that our former county attorney, Mr. Bill McNally, recommended that the county engage you in defense of this sign ordinance based on your experience and the fact that it's an area of specialization for your law firm?
That's correct.
I understand that based upon the decisions that have been made, particularly in the Fulton County case, that we would be facing damages, monetary awards. Can you give us an idea of what the monetary damage awards, and just in your estimation, would be if we do not settle this?
The awards are substantial. Most billboards are erected, and damages would be calculated over a 10 to 20 year period. And per sign face, you're probably looking at an annual damage award of about $750,000 or so per year. It could be a little more, it could be a little yet less, but when you project that over 10 years, even if you reduce it to present value, it's going to be a pretty sizable sum.
In your professional opinion, what's the probability that the county will be successful should we decide to continue and pursue this litigation?
In lieu of the Galbraith decision, very little. It's a very low probability.
Can you tell us approximately how much more in legal fees we will incur should the county decide to pursue this litigation?
We would have to hire some expert witnesses. We would have to set up the factual groundwork for the trial in the Superior Court. We would have to conduct that trial, which would likely take at least a couple days, possibly 3 days. So you're looking at another probably $100,000 for our side. And then were the county to prevail in front of Judge English, who's already ruled in favor of the county twice and been overturned, the plaintiff would no doubt appeal, and you would be dealing with another appeal. So you're probably looking at $150,000 in defense cost. In additional, if you choose to proceed, and that includes expert witness fees. And if you lose, ultimately, then you have some exposure to attorney's fees for the other side, and their fees normally accrue at about twice the rate of ours because they charge a much higher rate per hour.
And you're recommending to us that we accept the settlement in lieu of continued litigation, and I think you've reasonably explained why. The question is, will the settlement of this case have any bearing on our current sign ordinance, and if not, why?
It will not have any bearing on the current sign ordinance, and it will not have any bearing on any new permit applications that come in. Once I got involved in the case, one of the first things that we did was make sure that the county had a new sign ordinance that was completely different from the pre-existing ordinance under which these permits were sought. I believe that that ordinance is in good shape. And anybody who would apply for a sign permit from this point forward would have to come under the new ordinance, not the old ordinance. So I do not believe this gives you any exposure under the current ordinance at all.
Gentlemen, any further questions?
Mr. Chairman, I apologize for being out of order. Would you instruct counsel to identify herself for the auditory record?
I'm sorry, my name is Laurel Henderson. I'm with the law firm of Henderson and Hundley in Decatur, Georgia.
Thank you. My apologies.
Thank you. Gentlemen? No questions? Gentlemen, have a recommendation, Councilman? Or do you have a question? Do you have a recommendation from council to accept the settlement, which in effect would require us to pay $50,000 in attorney's fees, $5,000 to the plaintiff in settlement of all claims, and the location of 2 billboard sites on North 85, on 85. What's your pleasure?
Mr. Chairman, I'll make a motion to accept the offer of compromise in the matter of Coffee and Cannon versus State Neighborhood Commission and authorize chairman to sign the documents.
Have a motion and second. Any comments, discussion?
I'll just comment that I oppose the motion. A couple of reasons. We've had several back and forth discussions, and I think we've got a difference in semantics that we lost 2 times at the Georgia Supreme Court. That it was simply, in my view, sent back to the local court to be decided. And I think we lost, they didn't lose, nobody lost. And the other concern of mine is that for commercial enterprises, this does not make us immune to future lawsuits. Just think we can figure that out.
Any other comments?
From what I got to say, I think the taxpayers are at great risk if we go forward with this. I think that I have to take counsel's advice on this. Not anything that we would like to do. No one would like to put up billboards. But when you put in a position like this, I think it would be a foolish thing to not do in lieu of taxpayers and money that cost taxpayers in the future. So for that reason, I'm supporting this motion.
Anything else? I think, thank you for your efforts on behalf of the county, and certainly given the options we face, none of them are particularly appealing. Unfortunately, we find ourselves sometimes in positions that we have to choose the lesser of the evils.
I agree.
And in this case, it's the lesser of the evils and expense that we're faced with. I'd also like to note for the record that the majority of this board inherited this lawsuit. It was not of our making before we arrived. Unfortunately, that doesn't give us the ability to dodge dealing with it as much as sometimes we would like to. But thank you for your candor in this matter. Thank you for the efforts on our behalf. Gentlemen, I'll call the question. If you would support the motion, you read the motion for us.
Commissioner Maxwell moved to accept the settlement requiring the county to pay $50,000 in attorney's fees and $5,000 to Mr. Coffey to allow the location of 2 billboards on Highway 85 and authorize the chairman to sign settlement documents. Commissioner Frady seconded the motion.
I think that was before we get to 7.
Second, if you will.
Or maybe it was a joint second. Gentlemen, you've heard the motion. If you support the motion, signify by saying aye. Aye. Opposed likewise. Thank you. Thank you for your efforts, and thank you for making the trek down here to explain all this to us.
And if I could get these signatures,
Yes,
I
ma'am.
hate to interrupt, but that would be really